David Leon Riley was a member of the Lincoln Park gang in San Diego, California. A police officer pulled Riley over one day because his car had expired registration tags. This meant the car needed to be searched and impounded. The officer found 2 guns and arrested Riley for unlawful possession of firearms. An investigator searched the cell phone that Riley had in his pocket at the time of arrest. The investigator discovered photos and videos that showed Riley participating in gang activities. Further investigation about Riley's relationship with gangs led evidence that linked him to a gang shooting. Riley claimed his conviction should be diminished because the officers violated the Fourth Amendment when they searched his phone. The Supreme Court heard the case and ruled in favor of Riley.
Are you aware that your registration expired last week?
No, ma'am.
Alright, I'm gonna need you to go ahead and exit the vehicle at this time. If you could just stand over here to the side, please, I'm gonna search you.
Three.
Sir, you're under arrest for gang-affiliated crimes.
What you witnessed may have just violated the Fourth Amendment. The legal question being argued is, can the government conduct a warrantless search of the contents of a cell phone seized after being arrested when no exigent circumstances exist? The arguments made by Chief Justice John G. Roberts was the court held a warrantless search on digital data that cannot harm an arresting officer. However, Justice Samuel A. Alito expressed doubt that the warrantless search exception following an arrest exists for the sole or primary purposes of protecting officer safety and preventing evidence. All right.
At ease. Generally, officers must obtain a warrant before conducting a search of the contents of a cell phone seized incident to an arrest. Otherwise, a Fourth Amendment violation occurs. The majority reasoning, the exception to search a person incident to an arrest is a valid exception to the warrant requirement of the Fourth Amendment. The exception is permitted for officer safety and to prevent destruction of evidence. However, no safety risks exist in a cell phone that warrants intrusion beyond a preliminary search to make sure that the phone is not holding a weapon or a small blade. The court then distinguishes the warrantless search of a cell phone from other objects, such as a cigarette container.
Court upheld
The trial.
the trial court's conviction. Another defendant, Worry, had his flip phone seized incident to arrest. Officers used the item seized in the phone to secure a search warrant to search Worry's home. After the district court admitted the evidence found at the residence, Worry appealed. The Federal Court of Appeals found that the evidence was the fruit of an illegal search of the phone.
Riley v. California established that a search of information found in a cell phone is not a proper search incident to an arrest. Due to the personal nature of information stored in a cell phone, a search warrant must first be obtained. The court had a final vote of 9-0 in favor of David Leon Riley. Riley v. California has not been overturned to date.
Riley v. California, 2014. Facts. Argued April 29th, 2014, and decided June 25th, 2014. Officers pulled over Riley for a traffic violation, which led to his arrest on weapon-related charges. Riley was searched after his arrest, and officers seized his cell phone, from his pocket. Riley was convicted after a trial where evidence seized from his cell phone was introduced in a shooting-related charge. In response, Riley appealed his conviction to California State Court of Appeals.